set.
Are we all set?
Yep.
All right.
So if I can have your attention, please. I know we've been waiting a little bit. We were going to start at 6 p.m., but we're going to start right now. So let me introduce myself. My name is John Connell. I am here, I'm an attorney. I'm here as the legal advisor to the Board of Appeals. Now, typically, the legal counsel doesn't start the meeting or speak, but since the board has not met for quite some time, and I understand there's some new appointees, thought I might just help facilitate to get the meeting to order. So why don't we start, if I may, just by short introductions of the board so everyone here knows who you are.
Hey, I'm Amy Norvell, I work here in Unity, and mom.
You don't have to give a whole life story.
I'm a fundraiser, I love being outside, and that's who I am.
Great.
Like to contribute to the town, like that.
Great.
I'm Dave Ulrich. I grew up in the town here and I'm serving on the appeals committee. Started there 2 years ago, but this hasn't really met, so we just get it going today. It's upcoming couple of appeals that are on board.
Great.
I'm Valerie DeRozier. I live at 14 Cross Road. I'm on the Board of Appeals. I've lived in town for a little over 10 years.
I'm Brian Goudet. I moved here, gosh, I don't know, 96. Run a business in town and happy to be here to help out with the appeals board.
Excellent.
My name is Matt Curtis. I've lived in Unity for about 30 years. Moved all the way from Belfast. College brought me to town, and I just never left. I live in town with my wife and children, and very proud of my family. And I currently serve as the chief deputy at the sheriff's office, and I was asked to join this board. Probably 15 or more years ago, for about a dozen years, I was on the planning board for the town, so I some knowledge of some of that stuff. So, but yeah.
So, as counsel, I'm just going to declare, and please speak up if you object, that there definitely is a quorum of the Board of Appeals here. So the meeting has been called to order. We definitely have a quorum. So the third item on the agenda is to, we call it organization of the Board of Appeals. What that means is you as a board need to select who's going to be the chair, who's going to be, you call it the acting chair. I think that's the vice chair. If the chair is absent for some reason, the acting chair or vice chair steps in and fulfills that role. The other position, if you will, is the secretary. The secretary helps keep records, etc. Although typically with the capable support and assistance of Charlene and others of the town, including myself when I'm here for these proceedings. So those are the three positions, if you will, that you as a board, you need to elect someone to each and every single one of those. Now, what typically happens is you can talk amongst yourselves on who you might think would be interested in doing those positions, but when you go to actually elect that individual, someone nominates the individual, you might have more than one nomination. You might have some competition, although it doesn't happen quite often. Once the nomination cease, then you vote on whether that person, should have that position. For example, the chair, acting chair, secretary. So my suggestion is you actually go in that order. It's very typical to pick a chair first, then see who would be the acting chair or the vice chair, and then the secretary. And just to be clear, I want to make it state that Valerie, she is an appellant in another item, but she can still remain as the board as part of this organization, because doesn't matter what else is on the agenda, so all of you get to pick
Sure.
who wants to be chair, or who gets to be chair, excuse me, vice chair and second chair. So I'll leave it at that. I'm here to help guide and assist you, but it's really, who's willing, or who gets elected to do those positions. And don't all jump at once.
I would prefer to someone that's been on the board for a bit as the chair, but,
Agreed.
that would be my only,
And I'm new to this, so
that's my-
I'm not a very good secretary.
Yeah.
I'm new to this as well.
Yeah, but I don't know that.
We're honing in on you, David.
Well, no, I mean, I
It's
think
not
that,
really appropriate for me to be in a position on the board.
It's,
You still could, but if obviously if you had let's say that you were the acting chair or chief of the and you had to step down as part of a conflict, what we would do then is, as part of that proceeding, we would have kind of like an interim, whatever the position is.
or if you were to be the chair, that's why we have the vice chair. Or the vice,
Right.
For example.
But I don't know how, I mean,
I heard David just done.
whatever I can, I think that probably you'd be more appropriate as a chair of the house than another two. You probably have, she has some experience on this committee, but you did a lot of planning. board, so
Yeah,
if you're
I-
interested, that would be.
I don't care if I'm the chair, but obviously I'll have to step.
that's fine. I mean, for the sake of this one, I mean, all right, I'll nominate Val as chair.
Yeah, and I'll second that.
Are there any further nominations? Seeing none, I'll consider the nomination cease, so you can vote in favor or against that. Who's in favor of Val chair? Okay. Okay, you were the chair. So next up is acting chair,
We'll make that now.
which will be the chair.
I
Yep.
nominate Matt Curtis as the
I'll second.
acting chair.
Right. Any further nominations? Seeing none, I'll consider that the nominations have ceased. So you guys, all those in favor? Okay. Now you be the acting chair.
Right.
And technically, Valerie, you should be doing as chair, you can be the secretary, but we'll keep going here. Who wants to be secretary?
I nominate David Aldrich.
Second,
Seeing no further nomination, we'll consider those closed. All those in favor? Okay, great. So, unless there's anything further from the board, I would consider that the conclusion of your organization meeting of the Board of Appeals. So obviously, for the next item, that's an appeal where Valerie is appellant. So Valerie cannot be on the board for the same appeal, so you need to go into the other area of the room.
yes,
And that means you, Matt,
yep,
as acting chair, will fulfill the role of chair.
sure.
And I'm here to help assist.
It's good, I'm gonna need a bunch of it. Well, I was just saying,
So I think it would make sense, just because we will have more than one meeting. So Matt is going to be, as acting chair, is now the chair for this proceeding, which means there's no interim, we'll say, acting chair. So I think it'd be good to have an interim acting chair. So if for
Sure.
some reason Matt is not here in a future meeting, we have
Okay.
some
And
backup.
I think he can just sign it. I think it's in the bylaws.
Well, now you're asking me to look that up. I don't know.
Might be on
yeah. Well,
there. Either way.
so,
I,
Ryan or Amy? Okay,
yeah,
okay.
I think, yeah, there's only two possibilities.
Yeah.
I'll nominate Brian as the interim acting chair.
Any further nominations? No. All right, all those in favor? All right. So for the purposes of this appeal proceeding, Ryan is the interim acting chair. If it's helpful, Matt, I
Yeah.
can give kind of a quick overview of
Sure.
item 4.
Yeah, I would yield to you for that.
Sure, thank you very much.
Sure.
So, yeah, so item 4, so this is regarding an appeal application, and the individuals listed in the appeal application are Valerie DeRozier, Michael French, Scott Freeman, and Kathleen Powers. Now, the notice of this meeting and public hearing was very specific that we're going to deal with what I call preliminary matters, preliminary items. It's items that you would address up front before you really get to the merits or the issues that are raised in the appeal. Because the board had never really met, so it made sense, one, we can do the organization part, get a feel for how the process works, but also try to address some of these preliminary matters up front. And then once that is concluded, assuming that it's concluded this evening, we would look at the calendars and start to play calendar matchmaking, quite frankly. One thing I want to be clear on is that for the preliminary matters, whether it's the appellants or the permit holder, permittee, they should have the opportunity to make statements or what their position might be on some of the items. Some might not be controversial at all, so there might not be any others. There might be some. We won't know until we get specifically to those. So before we do that, the very first thing and I want to go over is conflict of interest and bias. That's very important to do first. And the reason being is if you waited all the way to the end, then someone had a conflict. Well, guess what? We have a problem. We just went through the whole proceeding with that conflict. So it's something you definitely want to deal with up front. And I would always say, let's say there's no conflicts now, but one developed during the proceeding. Certainly bring that to the attention so we can address that. And how that works under the statute is even if there's a potential for a conflict, doesn't mean there is one. You err on the side of disclosure. And if there is items to disclose or are items to disclose, then you guys vote on that with some guidance from myself. So let me give you kind of a legal framework or parameters of what a conflict of interest could be. That way, hopefully, it's somewhat understandable. So you can figure out, well, do I have anything disclosed? Is there a conflict? So it's actually stated in the ordinance, what I'll call the economic test. And that's what you find in the state statute. Sometimes they call it statutory conflict of interest. So if you own 10% or more of like a business of one of the participants or parties at issue, that's a conflict. Pretty strict. It's pretty mathematical. So for example, for I'll call 5 pillars, if you have an ownership stake, 10% or more, you have a statutory conflict of interest. If you had an appellant that had some sort of ownership stake with them, that would be a conflict potentially as well. So that's the economic test under the statute. There's also what I'll call common law conflict of interest, which is not as precise as the statute. It's more of a narrative that, well, do you have yourself personal interest at stake or maybe a relationship that would make it difficult for you to be impartial and independent to rule on an appeal. So you might not be, I'll give you a random example. So if you were the CEO of a hospital, let's say the hospital is here, you don't own 10% or more of it, but you have a leadership position and you certainly have a stake in your own employment for that. That might be suggestive of a possible conflict in that instance. There's also another area that people often call conflicts. It's really a bias type issue. There's different types of bias. So for example, if your spouse was here, called that family bias, and they were either appellant or they were a permit holder, you should not be here ruling on your spouse's position, whatever they might be advocating for. The other one sometimes is subject matter. You have people with very strong beliefs, convictions that it just wouldn't matter. You would always vote yes on something or just always vote no on something. It can go either way. That may be suggestive of potential bias. So those are the things that, from my perspective, I want to make sure we clear it up front. See, are there any possible conflicts that you would even potentially disclose or bias issues? And so I'm going to look to the board members, because I really don't know whether there's anything that you're aware of that might be an issue from a conflict or bias perspective. And if what I said doesn't make any sense, just ask me to explain it better, hopefully.
We don't even know what the appeals are yet. There's nothing that's been presented to us.
Well, that's a fair question. So the one is you know who the individuals are that are involved in the business entity. So let's keep it. Does anyone own 10% or more of 5? All right, that makes it pretty easy. Is there any very close family relationship with any of the individuals? Do any of you harbor strong convictions or beliefs, pro-meat or anti-meat? So I'm not getting a sense from the board that you perceive any issues. Now, what I like to do as well, it's going to be kind of awkward, but I also like to look at both the appellants as well as the permit holders to see if they have any issues they want to raise of a potential conflict or bias issue. Because again, it's important to address that up front before we start to proceed down to the other elements. And I'm looking, one moment, I'm looking at the appellants. I know Valerie is there. I actually don't know if all of the appellants listed are here.
I'm Scott.
Thank you, Scott. Val.
Yeah, Val Rozier,
Thanks.
working question.
Okay, and the other two folks not here?
My husband's at home.
That's fine. I just want to make sure I'm not omitting them.
My wife's at home caring for our kids.
Great. If I may ask you, are there any conflict or bias issues that you want to raise to bring to the board's attention? This would be on the board members.
No,
Great. Now I'm going to look at I'll call it the permit holder. Are there any conflict or bias issues that you would like to raise regarding the board?
Bias adjacent. Bias adjacent. Do you want me to stand or?
It's up to you. I think I can hear
prefer
you.
to stay seated. It's been nicely informal so far. So.
As long as you can hear me and we can hear you, I think that works well.
And tell me if you can't hear me. I have been told I'm quite soft-spoken, so tell me to do so. I know how to do that. Our concern, which is not a legal conflict of interest, but it is a small town concern, is that you all with Val are Board of Appeals. And we are concerned that a sense of collegiality with your fellow board member may affect your decision. There's some tough procedural questions concerning the appellate, the challenger's record, and the record they failed to do, frankly, in the lower proceeding, that we're going to have to press pretty hard. And I want you to understand that we're doing that because it is our right to do it, and not because we are taking aim at a member of the board. We are strictly doing it in order to make a legal case about what we perceive as a failure to raise issues before the board.
I have a question.
Of course.
Okay, Amy, go ahead, please.
Oh, I just have a statement about the collegiality. Can I speak to that?
Go for it. I'll ask her.
So just, I'm very new to this. The last time I served the town was on the town budget committee, and I did it for many years. And then I took a big step away from that to raise my son. So it's been maybe 10 years. So this is like 10 years, like into back into the town stuff. This is the first time I've met Dave.
Right.
So I first time ever. I know Brian through, I used to work at community college. So I don't really think there's any collegiality, like he was a vendor. That's the type of relationship I feel like I have with Brian. I mean, I think he's a nice guy too, of course. And Matt was a neighbor. We lived on a dead end street previously. I moved, I bought a house on the other end of town. And Matt and I are alumni of community college, so it is a tight-knit community. I do agree with that. But for me, personally, yes, I think there's a friendly collegiality, but nothing conspiratory in my opinion. I feel like I am a fair minded individual, and when leadership of the town asked, I guess, to nominate so there could be a quorum, I said yes. And I've been a really busy person. My son's older. He's actually old enough to kind of be home right now. So like I'm here. I feel like I'm a fair person. So I think like that's not going to be a problem for me. Just that's my personal statement.
So what I'm kind of, if this were a court, then you would be asking for like a change of venue almost because of, is there any, that's how I'm interpreting that.
No, this is the right place to be.
Okay, I'm just wondering,
I think what I heard was, and I can be corrected, it's not a specific, Matt has a issue. I think it's more of raising the concern of
sure, no,
collegiality to the board member. One of the board members of the
None of
appellate.
us have even been on the board, just established, so we haven't
Right.
So I would like to say, with all due respect to everybody here, I know you guys, you're donating your time and you are trying to do diligence to your duty. And I really, and my wife, our attorney here, is respecting what you are doing. Our attorney here can address maybe further down the road some issues raised that happen maybe, or we experience that make us make this step.
Well, that's fair. So I think what I'm not hearing is for each individual board member, whether, Dave has a very close family relationship with Valerie. I'm not hearing, that's not an issue.
Yeah, I mean, we're acquainted, we're friends, but we know, I mean, I'm a really great friend with Brian, with everybody. We're not that, I don't really know you that well because we just haven't run into each other at the store, I guess, but I like meat though.
Let me put it on your, go ahead, please.
Can I say something? I joined this board to set my personal feelings aside.
Right.
To serve the people of the town of Unity.
Right.
I've become friendly with Hassan and consider him a friend. Good friends with Dave, Matt, Amy, Val. They're all part of the community. And I am here to serve all of those people and put my own emotions aside to do what is right according to our bylaws. And simply that, is do what is right, not according to my emotions and feelings, but according to how we have things written. And that is why I agreed to join this board, because I feel like I can put that aside and I don't have any conflict of interest. Even though I can tell you that Hassan hired me to do some work for him not long ago. David hired me to do some work for him before. I've worked for the community, but those don't matter in the situation we're in. I joined this committee to put those kinds of things aside, to use my knowledge to help make sure that we can follow the rules necessary.
So just to put a finer point on our concern, this is not just a matter where there's an interested party who is on the board who might be involved. We're talking about somebody who is an appellant. Okay?
Yeah.
And I want to make sure everybody understands that when I raise the facts and argue the law, it's not a personal attack on the individual board members.
Understood.
And to that end, there's usually and particularly as this is a new board, I think I brought it up with John. We will be very, very sensitive to what I would call ex parte communications. Which means that under the usual circumstances, anybody who's acting as a judge, whether it's a group or as an individual judge, is not supposed to be speaking directly about the issues or the facts with any of.
That's understood. So, but
If you would
with
like.
due respect, let's stick with conflict of interest and bias issues.
Yeah.
So we can, before we wander into other items.
The conflict I thought was related to the ex parte.
It's not. So if I think there's been a concern raised, I don't think there's an objection to any specific board member. Okay. So noting that for the record. So I think we're beyond conflict of interest and bias items. If something comes up in the course of the proceeding that changes, please let me know.
Sure.
I'm going to suggest going slightly out of order because I think subject matter jurisdiction should come next. I recognize I put this in the order that it is. What subject matter jurisdiction is whether you have authority to hear a particular appeal before you. I think that's pretty clear here. And I'll phrase that in two aspects. One is timeliness. So is the appeal in front of you timely filed? And also is the subject matter of the appeal something you have authority to even review? So here you've got a planning board decision that stems out of the land use ordinance. I believe it's July 30th, 2025 was the decision.
Correct.
I wrote that down, but I don't think that's in front of me. And I believe that the appeal application was August 28th, 29th. Thank you. So
29th.
there's a 30-day window to file an appeal application. So to me, that's within 30 days, based on my counting, so there's no issue on timeliness. I'm not seeing anyone raise their hand on that. And the other one's pretty clear to me that you do have the authority to review the appeal because it's a planning board decision coming out of the land use ordinance. You actually have both the land use ordinance that says you hear appeals, decision under that. You also have your Board of Appeals ordinance that says the same thing. So to me, it's pretty clear that you do have, I'll call it subject matter jurisdiction. The appeal is timely, and it also is a subject matter that you have the ability or the authority to review. So seeing no opposition or object to that, the record is clear. I'm going to assume there's subject matter jurisdiction. The next item is standing. And standing is one where someone has to be an aggrieved person under your ordinance in order to carry on, if you will, or have administrative standing to have an appeal. To give that some context, let's say John Pottle filed an appeal, and I live halfway across the state and have no connection at all to the town and community. You might question whether I would have standing. Do I have any kind of particular interest at stake, or am I just driving by once in a while? As opposed to someone that might live much closer to a proposed project. You can see the distinctions and differences between that. I understand from the permit holders, they do want to raise an issue of standing. This is the time to do that if they do want to do that. If they don't, that's okay as well. But the appellants should be prepared to hear what they have to say, and I'll also help guide the board to go through the standing item. I'm assuming the appellant's position is you do have standing.
Correct.
So that said, do you want me to speak?
If you have, now would be the time if you want to raise an issue on stand.
We did write a quick statement of our position and request for dismissal of this case due to lack of standing. And
How many copies do you have?
I have lots.
Okay.
So,
Make sure that,
yeah, we're hoping to find the comments as well.
Would council please address also us, just because it's difficult to hear you?
Oh, sorry. Right now, I'm just passing out paper. So,
They're gonna give you a copy of it.
you'll get a copy of it.
Would it?
Get beat in the other.
Well, not
Can
really.
I get one? Can I get one?
Thank you.
You can get
No, I gave you one.
Do a pass of it, right? So I haven't planned on making any remarks because I think the document speaks for itself. And I also know that, can you hear me now?
just pause and give folks.
You can just turn it
Do you want
on.
us to read it, or do you want to,
Yeah, why-
we can read it. Sorry.
It's quite short, so I'd say take a
Let's take the time.
Yeah.
minute or two to read
I
it.
understand.
Allow the appellant to read it as well. They should have an opportunity to respond to the request.
Oh, Dave's still
Yeah,
in.
yeah.
Yeah,
But
I guess my question would be, at this point, I mean, they presented this, do we want to give them a chance to speak to the letter, if there's anything
of
beyond the
course,
letter? And then,
yeah, I think the request is being made by Attorney Yard. I think you want to make a brief
Yeah.
statement. But then, absolutely, the appellant needs the opportunity
Yeah,
to respond.
So you had a chance to absorb what I wrote. I tried to keep it as, okay, to the point and short. as I possibly could. But we had a protracted planning board hearing. It was long. The primary issue was, of course, the
Septic.
septic.
Mhm.
Okay. But it doesn't mean there weren't other issues that were there. Now, when the planning board makes its findings, there's a whole list of the things they need to address, and two of them are noise and light. So the appellants say that they raised noise and light issues in the first hearing. We haven't found any evidence of that. Moreover, I would say to you that raising an issue and saying you have to think about noise and light, how it's going to affect us, is not participating fully. If you are concerned about it, you have the obligation to come forward and say, this is how it will affect us. You know, my house is 300 feet away, I'm going to be able to see their lights and whatever. Nothing. Nothing on the record. Nothing at a hearing, although they contend that they attended many hearings, which means they also had many opportunities to step forward. Nothing in writing, submitting your position and giving the board any guidance on how they would be affected by noise and light. So that in fact, the first time we learned that they had particular concerns about whether they would be able to see a light out of the front part of the house as opposed to any other part of the house was in this appeal. That is not how it's supposed to go. You're supposed to raise the issues below and get them all aired out. Take your position, give the other side a chance to respond in the context of the planning board hearing. That leads me to wonder what the definition of an aggrieved party is. Is an aggrieved party someone who made the best case they could below as the procedure was intended? Or is it somebody who waits to find out what the final decision is, attends the final hearing, says nothing about lights or noise, then decides they want to tinker? The legal argument that Mr. Rozier advances about there having to be a specific finding of what the intensity of the light is simply doesn't exist. There was no requirement for a specific finding. It was simply guidance as to the things that should be considered, and there is no indication whatsoever that the board would have decided any differently. But I think the real issue here is whether they had enough of a basis for issuing a permit as they did with the conditions they did, and whether you're going to get somebody who sat on their hands, sat in the background, waited for the final decision to occur, suddenly become aggrieved because they did not like what the terms were. And that, I think, is what you have. I have two more comments about this. One is, you're going to need to see the record to understand what I'm saying. I'm not saying you need to make this decision tonight. I'm not saying that Ms. DeRozier and her fellow colleagues can't argue against what I'm saying as a matter of law or point to areas of the record where they contend they actually complained about the fact that they shouldn't have to have any noise whatsoever overnight. Isn't there? But if they can find it, we'll listen. So I would suggest that we know our position, understand our argument, give them the opportunity to respond tonight if they want to have it, and get into that record and find out whether this is an appeal that should cover it from water, or whether it is somebody who simply sat on their rights and now is unhappy with the result. That's not an appealable grievance.
Thank you. Do you want to talk tonight, Val, or do you?
Good evening, board, and others. On or around April 23rd was the first public hearing that the public was allowed to bring their comments forward on the project. At that time, I brought up that I thought that it was not unreasonable for the board to please consider not only the lighting and the noise and the sounds from the proposed slaughterhouse, that those needed to be considered, that the ordinance does address screening for both myself and my neighbors, which obviously Scott and Kathleen are also abutters and my neighbors. The second public hearing was in July, and the town attorney for the planning board specifically said in the beginning of the meeting that the public hearing was only to address the issues related to water quality and the septic system. And after people could ask those questions, she then said that the meeting was no longer open to any public input, and that the planning board was gonna capitulate on the points that have to be met in the ordinance. While there was dialogue between the folks with the slaughterhouse and the planning board, I was led to believe that the public was no longer allowed to speak. And so we were only allowed to speak about the water quality issues in the septic system. So I didn't say anything, or else I would have. All the planning board meetings that I attended, the information was all over the place. You know, we didn't even know what the hours of operations were gonna be. It took some time before we even knew that they were gonna light the buildings 24/7 because they're concerned about security. My house faces the portion of the building that's gonna have the docks where they're gonna load and unload the processed meat, as well as to pick up the offal and the parts of the critters that aren't gonna be sold as meat. And the hours were only limited to from 11, they can't work from 11 PM till 4 AM, but they can work 7 days a week. I've lived in a residential quiet neighborhood for 10 years. Some of my neighbors have lived there much longer. This is a huge change for us, and I think we deserve consideration. Thank you.
Can I ask a question? So where is your property? You own property?
My property is on the crossroad, 14 Crossroads, so my front of my house faces, our road, and then there's a buffer of about 50 feet, which is deciduous trees, which means the leaves come off in the winter, so I can clearly see through to the new slaughterhouse building. And I'll let Scott, tell you a little bit about his property and his son.
You're up, you're ready.
I'm Scott.
You could take that out of the, you could take that out of
Hold on,
the.
you want to
I
talk?
can check, I'm a teacher. My name is Scott. I live at 136 Bangor Road. It is directly across the street from the proposed site. My wife and I attended the first open comment meeting. We both brought up issues and were almost immediately shot down by the board. We live on a busy road. I remember, it struck me right across the face roadway. yeah, we're on a road, but things need to be considered. I attended multiple of the meetings next door where my understanding is I was not allowed to talk because I was not the one bringing the application or part of the board. As Val pointed out, the idea of when the hours would be were all over the place, and I didn't hear about any of that until way far down the line. And the hours that are now in paper settled are insane. My child's window is right into that area.
Please do this portion. Yeah. Go ahead, continue.
Yeah, it's not violent. Like there needs, as I tried to bring up at the first meeting, there needs to be some sort of barrier or mitigation effect that is doing it, taking care of it. I've tried to bring this up before, I've shown up to many meetings. I teach the April special ed, I'm doing the best I can to show up these meetings, do it as I know. But this isn't exactly my forte.
So your property, you own property across the road
Yes.
from the project property.
Yes.
And is your wife Kathleen Power?
Yes.
You guys own the same property?
Yes.
What is your address?
136 Bangor Road.
Is there chalk for that chalkboard?
Is that that used to be Todd's place, that yellow place beside? Cool's?
Yeah, it's yellow place.
Yeah, okay. I know exactly. Thanks. I lived there when I was in college. So,
Oh, how can we do this? So does everybody know where Coolin's Apartments is?
right.
Yes. You're right next door to the yellow house, right?
I am the yellow house.
Yeah. And for those who don't know, Valerie is, if you are next to Coolin's, you've got, there's a camp road, then you've got Scott's house, and then you've got Val and Mike own what used to be, or is called the Ponderosa Barn, an old chicken barn in the field. And directly across from that is where Val lives.
Crossroad.
On the crossroad.
Yes.
So Val faces basically the side of the Five Pillars Butchery. Scott, you face directly, basically the front
Yes.
of
The front facing the route.
the butchery. So I hear what you folks are saying. May I address this on with a question?
You can ask questions to the board.
With your intent for lighting, because I understand the ordinance in Unity is we cannot light signs from below.
And I don't mean to, depend, yeah, so let me try to hopefully clarify. So for standing, you don't make the determination on, oh, they're actually being adversely affected or not. That's,
I'm just trying to paint the picture for everybody.
Okay.
Right? So I get a better understanding of where you folks are coming from. And also want to get an understanding where Hassan, what his proposal is. Because my understanding is we can't light things from the town ordinance from down below. If I put a sign up for my business, I can't have lights from down below up. Because they shine into somebody's home.
Or internally lit.
Or internally lit. So
Unless it's one of the.
I guess my question, so I can understand better, is the Five Pillars Butchery, are they gonna be lighting outward from the building?
so here's the way I would suggest looking at the standing issue. And there's actually a definition of an agreed party.
I just want
Yeah.
to, did you have something else you wanted to add? I know we kind of went off. You say that again?
I was waiting to be.
Oh, if you're
No,
all,
you don't have
you
to.
dismissed yourself. That's
Okay.
So if it's helpful for the board,
Yeah.
so let me try to put this in a little bit more fine tuned perhaps. So
The planning board, the plan has the lighting.
yeah,
Proposed lighting.
I would suggest this, don't just focus on lighting or some other factor. Let's just look at who the appellants are, what is their relationship to the project or not the relationship. So an aggrieved party, this is on your land use ordinance, I'm gonna read from it, because I think it's helpful. So an aggrieved party is an owner of land whose property is directly or indirectly affected by the granting or denial of a permit or variance under the ordinance, or directly or indirectly affected. A person whose land abuts land for which a permit or variance has been granted, or any other person or group of persons who have suffered particularized injury as a result of the granting and the denial of such a permit or variance. So the reason why I was wondering, where do they own property? Where do they live? Because for me, it's instructive to see, well, how close are you to the project? So if you're John Powell and you live across the state, I don't really have much, I'm not looking at anything.
Right.
But if I'm a direct abutter,
Sure.
that's a pretty easy question. So, from my standpoint, and I very much appreciate I'll say the position or the argument, well, they were certain issues that weren't raised before the planning board. That's a fair thing to bring up in the course of proceeding, but whether or not an appellant has standing is really looking at, well, what type of interest do they have, where do they own the property, relative to the project parcel.
This is different than standing.
I will tell you, in the administrative context, standing is not a very high bar to meet. And I'll use this as another example. If this is actually in an old court decision, where a judge said, well, there's no such thing as drive-by standing. So if all members of the public, drive by, that's not suggestive of particularized injury. I'll give you a different example. There's a case where someone said, well, I have an issue with the Baxter State Park. But they allege, not only do I have that issue, but I go there. Usually that was enough to have standing in that instance. So generally speaking, the courts are pretty, I wouldn't say forgiving, but they tend to find that there is standing. Not in every single instance, because there may be circumstances where you're no different from any other general member of the public. When you own or live property that's quite close or proximate to a project, that's pretty suggestive that there is standing. Doesn't mean that ordinance standards are met or not met. It just means they're standing to continue to process the application.
If I may just. The first hearing I attended was on April 23rd. There had been hearings before that. The final hearing was on July 3rd and had a reserved time. Absolutely no prohibition on the appellants having submitted their objections and arguments and facts they wanted to put forward in writing, looking for consideration by the board. That was not done. There was, in fact, a specific statement by the board counsel at the time that she was leaving the record open. That means that at any time, with any of these scheduled hearings, these people could have asked to be put on the agenda, or if they didn't want to speak and get mixed up in what was actually a fairly contentious hearing, I'm sure you've heard, about the wastewater treatment, they could have submitted their objections in writing with proof and circles and arrows and made their points. But they did not do that. And in fact, Ms. Roger sat through the final hearing, and the only thing she wanted to talk about was a geotextile barrier in the wastewater system. By that point, the findings, requested findings have been decided. Says that the hours of operation are ridiculous. No, our standard hours of operation are ordinary business hours. You'll find on the record that the problem we have is that farmers come from far away and occasionally get hung up. So what we wanted were hours, and this was discussed on the that would allow us to let the farmers in the door so that the animals would not be harmed. There are standards for care of animals in transport to a facility. So the idea behind this, the hours of operation, was not that they would be used, but that they would not create a problem if on occasion a delivery was made. Now, the accountants could have simply waited to see whether they were effective or not. They could, still within their rights, have brought some sort of a nuisance action, but that's not what they're trying to do. What they're trying to do is reopen a proceeding they did not fully participate in, to their detriment. And that is why I say, when you decide what an aggrieved party is, you have to decide whether a person is, whether that definition includes somebody who's trying to get a second bite of the apple. There is law in the state about standing, which says that when you look at your own standing requirements, you can interpret your own ordinance and put what restrictions on it you believe are fair. Not opening appeals to somebody who has preserved their rights is not fair to my client. We're not talking, if you look at the appeal, we're not talking about minor remediation here. We're talking about a line, 100 or so foot line of evergreens, a minimum of 10 feet tall, all along Ms. DeRozier's property line, so that she will not have to see lights from the neighbor. She has not said that they're going to be too bright, she's just said she's never had to look at them from across, from the front of the property. That's not enough to reopen the proceeding, put my clients to significant landscaping expense. Neither of them told you how far their houses are from, their actual houses are from the lights or from the noise on this very busy road. They have not even attempted to explain to you why an occasional delivery after 6 p.m. is so out of the realm of possibility that they need a screen of 10-foot evergreens in order to be able to live in a residential neighborhood, which is another thing. This is not a residential neighborhood. This is a rural neighborhood. Rural neighborhoods that allow commercial development, and more particularly, and in the interest of unity, agricultural development. You can't let people who sat on their hands through an entire proceeding reopen a proceeding that they didn't participate in. Thank you.
So good. Up to the board, but from my standpoint, whether a standard is met or not met has nothing to do with standing. Standing is all about whether or not the appellant has presented a situation that they are either in the butter, and the butter them across the street based on the definitions, or they have a directly or indirectly if they're a property owner affected by it. Doesn't mean that, it doesn't meet the standard, therefore they have standing. That's not the standing. As opposed to just someone from the general public who really doesn't have any relationship.
Sure.
Right, in a state.
I would say, I mean, if that's something that we have to determine here, and based upon the definition you provided us with, and that's what we're paying you for.
Take a vote.
Yeah, I mean, we can vote on that. If someone I've entertained a motion, if there's someone that felt they had standing. Does anyone feel that the appellants have standing? Do we have to move for that?
They're bottom, I mean, I feel that's in.
All right.
But
I don't know how you want to say it.
I don't know how you want to do.
It's not clear to me they're butters necessarily, but it sounds to me from the description that they're in close proximity.
Well, I mean, the key is, if the middle of the road is, property lines are determined from the middle of the road. If you, depending on where you.
They direct.
You do define the butter as across the street, I just don't know if it's,
I'm not saying if that's standing, then.
that's pretty
I'm
close.
talking about standing, not whether, this may have merit, that doesn't have anything to do with standing.
Yeah,
That's right.
merit and
That's right.
standing.
Don't take away.
Right.
But the street,
No.
That's certainly
we are
possible.
next to them, so.
And I know physically where.
I do too, I know.
I
where
think
everybody
everybody
lives,
so they have
so we're-
standing.
I think y'all should be good neighbors, and so everybody can, you want everyone to be, but you have to, so we, that's why we're here.
So
So,
we're
but
voting on standing.
we're talking about
Yeah,
standing,
just
you're
stand.
right next to each other, everybody is, so.
I feel that they have standing.
I make a motion that
We find they have
we
standing.
find that they have standing.
I'll
So-
second.
Now, one thing for the acting chair is the board, when you vote on these matters, your ordinance says you do a roll
Roll call vote.
call vote.
All right.
So that
I will
means,
call the roll. Amy, do you think they have standing?
Yes.
David?
Yes.
Brian? Yes. Matt? Yes.
all right, that's standing. Next on the list is the standard of review. So let me explain what that is, what that means. So there's typically two standard of reviews. Now, you're an appeal authority, so you're hearing a decision that was made previously. Now, there's, in general, I should say, but I'll just say typically there's two types of standard of review. One's called de novo, or kind of fresh. The other one's called appellate, sometimes purely appellate, which is not fresh. It means you look at a pre-existing record that's already been established, looking at that, say, well, are there factual findings supported by substantial evidence? Are there any errors of law? That's the appellate standard. De novo, you don't look back at the prior decision maker at all. You accept new evidence. You look at you step into the shoes, if you will, of whoever the prior decision maker was, whether it's the code officer or here at the planning. So how do you know which standard of review to use? So in Maine, you look at two different sources. So the first one is the statute, and under the statute, it's de novo. That's the default standard. So under the statute alone, the Board of Appeals, you do a de novo review. The second test, though, you also look at, well, what do the ordinances say? Because a lot of ordinances say, well, the Board of Appeals, they conduct an appellate review whenever they review a planning board decision, and they conduct a de novo review if they review a code enforcement decision. That's just a random example. You often see that. Sometimes it says something different. In some instances, the ordinances don't actually use the words de novo or appellate, but they'll use language that is indicative of those two standards. So de novo, when you see a lot of references, evidence, cross-examination, all of those things. When you look at appellate, the words you're looking for are substantial evidence, clearly contrary to the ordinance, etc. Now, your ordinances, from my review, don't have the words de novo and don't have the words appellate in it, which means you have to look for and call the magic words. Probably not a technical term, but put it that way. So I've gone through and done that type of review analysis myself. And when I look at your Board of Appeals ordinance, as well as your land use ordinance, my conclusion or opinion is that you do an appellate review in this particular instance. The reason why I say that is in your Board of Appeals ordinance, it talks about when you review a decision from the code enforcement officer or the Board of Appeals, you review it as well as clearly contrary to the ordinance or unsupported by substantial evidence in the record. That is an appellate standard of review. There are some prior sections that talk about evidence and things of that nature. there's also other sections in your board of appeals ordinance where the appeals board, you review decisions, not just of the planning board and code enforcement officer, but of like the road commissioner, or in some cases, the select board. So that makes sense where you might be doing de novo for those ones, appellate for planning board. The other strong signal to me, why I come to that conclusion, is in your land use ordinance, if you look at the standards that planning board goes to specifically, like they did in this particular instance. Again, they don't use the word appellate or de novo, but the standard that they're articulating is an appellate standard. And the reason I say that is because in a very recent case that the law court reviewed of that exact same language in a different ordinance, a lot of this language was carried over from the community. And they determined that was an appellate standard as well. So sometimes you have different signals or indicators, so you have to go through that analysis. So my conclusion and advice was, I think you're conducting an appellate standard of review in this particular instance. The parties are free to state if they disagree with that. I want to make sure they have the opportunity to state that. It's my opinion, my conclusion. Under that scenario, what you review is a planning board record. And if you agree with me that is a standard review, we can then talk about, well, how do we get our hands on the planning board record? What is that? But first, the standard of review needs to be identified. Oftentimes it's very clear because the magic words are just right clear there. Here you kind of have to look at, okay, what does this language signify? Again, my review and analysis, appellate review, planning board decision.
I mean, to me, it seems like you've done your due diligence and to arrive at that recommendation. So I wouldn't see any reason to deviate, but to your point, allow these folks to, if they feel differently about it.
Do have this reservation advice, but have to look at the comments or something.
So the question is this, Val, so the standard of review that I was just describing, that's what the Board of Appeals is going to deploy. In my review of the Board of Appeals ordinance combined with the land use ordinance, the language that's using for planning board reviews, to me is signaling it's an appellate standard of review. The reason I come to that conclusion is the wording of the ordinance, comparing that with other ordinances and court reviews of that same language and coming to a similar conclusion. That doesn't mean I'm right in every single instance, but this would be the opportunity to say you have a different perspective, or if you want to lodge an objection, or, and the reason why it's important because it will determine, when we talk about the next meeting, if you're doing de novo, you're talking about witness testimony, submissions. It's like you're the planning board all over again. You don't look at a record. If it's the appellate standard, we do gather up all those record materials, and that's what you'd be reviewing for factual matters. Now, for any legal interpretation regarding the ordinance, it really doesn't make a difference for each one, but you look at that independently. But it's really on just pure factual matters. So I'll give you a random example. Let's say it was the height of a house. So the planning board record has materials in it that describes the height of the house. Well, you would just look at the record and say, well, is there substantial evidence a reasonable person would accept it's true? Say, well, they came to the right number. If you were de novo, you wouldn't look at any of that. You would say, give me some information on what is the height of this house. You would get that as the original fact file. So that's kind of the distinction.
I'm fine with the board handling it the way as an board.
So I just want to be sure that everybody, including my clients, understands. This means that if it wasn't on the record earlier by competent testimony or evidence measured on a planning board standard as opposed to a legal standard, is not in front of the board now, so there can be no arguments concerning concerning the inadequacy of deciduous trees to block. We did not actually ask for fir trees.
But the way I propose it is there's no new evidence allowed. So the record is the record. People can argue whatever they want to argue.
People will argue whatever they want. Exactly.
But yeah, but to the point is, let's say that there's a plan, let's just call it a landscaping plan
Sure.
from the planning board. Well, that's what you might be looking at. If the appellants or the permit holder or someone else shows up with a brand new landscaping plan, say, no, it's not, unless it was submitted to the planning board,
Right.
that's not part of the record. So, one of the, well, so it sounds, I'm hearing the concern lodged, but I'm viewing this as an appellate standard of review. I don't know if the board, took the board to determine that ultimately.
Right.
And we can argue with the record material later.
Right.
Yeah.
I was gonna say, I mean, I don't think it's gonna determine this. I guess my feeling would, I don't think it's gonna, I'm pretty confident that people are, whether it's, you folks are gonna bring up whatever points you wanna bring up, and, I'm pretty comfortable that's gonna happen, I think, but from a procedural standpoint, we have to identify what type of review.
That's correct.
So do I need to do a roll call vote on that?
I would do a roll call vote on the standard of review, and my recommendation is the appellate standard of review.
Did you have anything else you wanted to say?
Just one thing, we won't be relying on this heavily. And if the board starts to hear facts not in evidence and show signs of entertaining them, we will be rejected.
Sure.
We will be rejected.
Yeah.
And we will also, if you intend to hear any kind of testimony from the appellants and insist on it, we will also reserve those that provide the law.
Sure.
Okay.
Yeah, from a practical standpoint, I mean, this is a local board of appeals, or, people from the public to be able to provide comments.
Sure.
I will tell you right now, they're not supposed to introduce new evidence. Now, some people do that, sometimes that happens, but that's why I'm here, to help instruct, say, that's new,
Right.
so you can't consider it. But, there's some practicality that comes into play, but I'm very mindful of, no new evidence when it's the appellate standard of review.
We'll be watching.
Sure.
Fine. We're just determining the standard of review.
Okay, there you go.
Do you will you take a question?
So, we have the appeal in regards of tree lines, lighting. I'm 100% sure we covered this aspect through the development review, and it's in the records, documents, and the video recordings on the board, I would say YouTube channel, or the town YouTube channel, all the records is there. So we covered the lights being approved, the tree lines being discussed. We have the neighborhood that's supposed to be affected by the tree line, they refuse because it affects the wildlife and visibility. We through the development review, we push the building inside about 100 feet inside the property, so we don't block visibility. My point is, are we going to go after the facts through the development review only in regard to this specific form, or are we taking it all over again from A to Z?
No, it's just the matters raised on the.
Yeah, so,
Okay, thank you.
so under the standard of review under appellate, the appellants get to raise the issue. But if it's a factual matter, what's the appellants? You're looking at, is there substantial evidence in the record to support the finding of the plan? We won't get to that until we actually look at the record.
Right.
Hear the argument. Right now, it's just a standard review.
Okay, you guys ready?
Just so you understand, we're just keeping the power.
Understood.
Sure. Amy, do you feel it's the appellate standard of review?
Yes.
David?
Yes, I agree.
Yeah, I would agree.
Right, and I agree as well.
Okay, great.
Okay.
All right. The other item, and this is something that I don't think we should sit here and itemize what the record actually is from the planning board. What I would suggest is that you kind of direct me, I'll say I'm looking at Charlene, working with Charlene, but also the parties, to see if we can have clarity, or I'll call it agreement on, well, here's what the record is. That's just much easier.
So we can just stipulate that this is the,
Exactly. If there are some record disputes, I'll do my best to
Sure.
try to resolve that with the parties.
so you'll provide to us a clean copy of what the undisputed
Yeah.
record is.
What I'm suggesting is you are going to need to have the record, planning board record, whatever that's going to constitute. To get that, I think the cleanest way to do it is to have me communicate with the parties. See if we can identify, well, here's what that is, then you can get it. If there is a dispute regarding what the materials are, I'll see if I'll communicate with them to try to handle
Sure.
it. If we can't resolve it, we'll have to come back to the board and we'll resolve the dispute. But that way, hopefully it'll be more efficient to get the record materials in front of you. So that's my suggestion.
I certainly agree with that. How do you folks feel?
I agree, yeah, good to review all the notes from
Yeah.
the meetings.
Now, one thing I want to be clear on, and this relates to a comment earlier, so because you're only looking at the planning board record, don't go off and do your own investigations.
Right.
Don't talk to anyone, don't get any more information whatsoever. This is an ongoing proceeding. So if someone approaches you, say, no, I can't talk about that. It's still ongoing.
Yeah.
And don't, if you get excited, don't jump in your vehicle and drive off and collect your own facts.
Right.
Don't do that. Be patient to get the planning board record. I assure you it will come to you. This in part, I think that's the right process to go. The next part is going to be, when is the next meeting date going to be? And I'm going to couple that, I'm kind of looking at the appellants as well as the party, they'll say, your ordinance does not specify any kind of written submissions. I'm not suggesting it's mandatory. Sometimes it is nice to have something in writing if the party wants to put their position or their argument. Sometimes we call that a brief. And that can be helpful for the board, because if you're preparing for a meeting, you can look at or hear are the arguments from either side, for example. So in advance of the meeting, you're thinking about it. Don't talk to your fellow board members or anyone else outside the meeting. But sometimes that's helpful. Sometimes parties don't want to do that. They say, no, we don't want to do any written submissions. We'll just show up and do that. Maybe that's fine too. So I'm going to look first at the appellants. I'm looking at values. Do you have a desire or intent to submit something like a written brief in advance of the next meeting for board consideration? So I'll ask the same thing to Scott. I'm not suggesting you have to do it, but I'm asking.
I would assume that if the board had questions about, once they review the record of the planning board, I would assume that they have the option to review the ordinance based on whether it was our appeals application and the standards by which we're doing our appeal. Like, I guess what I'm saying is I don't want to regurgitate what's already available to them unless you tell me I should.
It's really just an opportunity. So let me give you an example. Let's say, I'll make up the date, on November 25th. I know the date that is. That's when the board was having a continuation of this proceeding to hear a presentation, argument from the parties. in advance of that, maybe it was 7 days in advance, you wanted to submit kind of a written statement or a brief, what your arguments are, you would have that opportunity. What I would like to avoid is if you decided to do that, you do it the day before, and then no one really gets a chance to look at it. So it's not that you have to do that, but it's an opportunity to do it. If you did want to do that, the parties want to do that. Let's just be clear, blank days before we next meet, submit your written statement if you wish to do that. That way it's just more orderly. And if you felt it would be helpful for the board to say, well, now I'm getting a written statement, you still get to show up, make your presentation, and your argument. It's just something to have in advance if you want to do that, that's all.
And by the time that sort of drop dead date is to get our arguments to the board, we will also have been provided with the record.
Correct, so here's what I was thinking, and I'm open.
Well,
Yeah. You figure out the record, and if the parties want to do written brief before making their oral presentations to the board, you have the opportunity to do that. I would say at least submit at least 5 or 7 days in advance, but it all depends on the next meeting date as well.
That's what I was gonna maybe suggest, something like, because obviously getting the record is the variable that we can't, I don't think there's an awful lot of, unless someone has a great guess, how long that's gonna take. And I'm looking at you guys.
It's in a bundle in the safe and it's that thick. It just needs to be scanned and sent out. That thick.
What's that?
Having lived through it might be more complicated than usual. So I was going to ask Jonathan how we intend to go about it. When we've got various videotapes, we've got anything being submitted to the board. I personally would prefer to have a written submission so that I have the opportunity to digest that record and show the evidence that supported the conclusions, point you directly to the evidence that supported the conclusions that they made, and so it actually can help. The written submissions can help digest
Sure.
things, okay? And that would be the purpose of having them. That said, we've got the time it will take to assemble the record,
Yep.
the time it will take to get through the record and identify things, the time it will take to write the thing. But once it's written, the hearing could follow fairly quickly.
Well, that's where I was trying to go with this.
Yeah.
I was gonna,
From my so the record, I speculate, consists of whatever was recorded from all the planning board meetings.
Right.
Maybe it's a video, maybe it's audio, maybe it's both. And whatever was submitted in paper or electronic form, that was before the planning board.
Right.
That's gonna be the record. Now, I don't know if all of that relates to the issue.
that's what I was
But
gonna,
that's part of
So,
what
I
I
mean,
need you to sort it out.
if we've got a stack this thick, but only this much of it is part of the appeal, then we don't need.
That's it.
So are you gonna sanitize this record?
Well,
for
I'm
us?
not gonna sanitize the record. In part, I would
I'm saying
say
is let us do that.
the obligation is on the parties that say, well,
Okay.
I believe that the findings are not supported by the record. Then you would expect some references or pointing out, here's why it's deficient.
Mhm.
On the other hand, if someone says the record does support the findings, you would expect to see references to why that party thinks that. So the written submissions actually can be helpful to focus
Summarize.
in on whatever those
Sure.
are, but it's not your obligation to come up with the presentation for both sides. That's up to them.
Okay, good.
Yeah, I gotta read through that once I
Yeah.
resign.
Yeah, exactly. Sam,
So, I would like to mention that the development review was really expensive on our end, but we made sure that we stay ahead of the game. and we didn't talk out of our mouth just to organize it. We brought a professional engineer and technical data documents. So the question here, is the process going to be, or anything to be submitted to the appeal board? Is it going to be done by professionals, or is it just for the sake of the organ?
I would say it's really up to you, so.
There's no new evidence, they're not going to be resubmitting what they submitted.
But I'm on their side, because if they have the chance to make a presentation for their case, I'm inviting them to hire professionals to defeat our claims that we did everything we can to make this, to achieve the goal to have this permit. I'm inviting them to revoke this permit if they can, but done by professional, because sending words out of our mouth, I can speak all day long.
So
It's not, I don't think this is,
it's really up to the parties, like, they can make whatever presentations that they would like. If they want to bring professionals, they can do that, you can do the same. Well, the one thing I will be very guarded against is, again, the new evidence issue. So if someone is, sometimes you may have, for example, a professional engineer who's discussing the record materials, but then that can deviate into new evidence. Sometimes we don't see that happen. But again, it's up to the parties to come up with
the record.
whatever,
Or what pieces of the record.
whatever
they feel
arguments they
relevant.
want to present, and who does it, that's up to them.
So whenever we can provide that, how long do you guys all think you would need to go through that?
My suggestion is, when are we gonna next meet? But Val, I think wanted to say something.
I just wanted to say that I want to make sure that the record of the review of this project by the planning board is certified by the town, and it's that the Board of Appeals will see the record, and it will be the same record that will be provided to us as is to them, so that we know that there isn't any additional information being added. Before.
Yeah,
Well, we don't hold any position in the town, you are the one.
My suggestion will be this, is that as counsel for the board, this is what I understand my mandate. I'll work with Charlotte. We'll come up with, here's what we think that it is. I will share that list with the parties so they can look at it. And even the materials, but that's how it typically just gets sorted out. If there happens to be a dispute on the record that we can't resolve, we'll come back.
Sure.
But usually it gets resolved without having.
I'm only asking how long it's gonna take so we can try to.
I don't think it'll take that long, from my perspective.
Tomorrow night?
Right.
Well, we'll assume, but.
Well, too bad.
Set a date, well, we're gonna set a date right now.
Well, I think
Now we're
so.
getting on to like, let's just.
Jonathan, if I may, with regard to the recommendation that raised, she's right. There is actually an ordinance on the front that says that the record must be prepared by the town, and as most of the reporters. So what I would suggest is if we could have some kind of decent itemization from you soon about what the record will consist of, that we can eyeball. She can be confident that if nothing else is going to be there, she can have the opportunity to inspect it. And if she thinks there's going to be some kind of a switcheroo, she can bring that up. I don't think that the ordinance requires certification, but it does require preparation by the town, not even the parties. So I guess we can do that. Then we can have a good discussion, and we definitely want the opportunity to point out all of the facts that were in front of the board when they set the hours of operation and didn't put up a 12-foot screen with everybody's on the property. So,
I'll work with Charlene,
Okay.
and in turn, I'll work with the parties.
right.
If there's a problem, you'll hear from me.
So do you guys want to try to pick a date and just,
So a lot of this is gonna come down to Charlene, I would imagine, because
Well, I wouldn't give them up.
you gotta dig out the information for the lawyer to review.
I have it all together. It's all, when we have a decision, it's all put together by the planning board. So all the papers are in one file. It's just a matter of compiling the audios that were, and most of those are,
Right, but who's gonna
Publicly.
pick out the pieces necessary for what we need to look at?
they do. We give them the list of everything that we have,
Yeah,
and then they make the determination of what pieces are pertinent to this case.
so in fairness to folks, all right.
Yeah.
My suggestion is that it can be somewhat laborious to go through the record and craft your arguments. Maybe it isn't, but I want, from my standpoint, make sure folks have enough time. The way I think is we're either gonna meet sometime before Thanksgiving or after.
That's what I'm looking at here.
That's what I looked at on, looking at that.
And as I told Jonathan, I have another wrinkle, and then I'm gonna be out of the country until November 17th.
So you wouldn't have a chance to review it anyway,
I
so
haven't had a
maybe,
chance to do anything, write anything, or anything like that, and please, get them.
are Mondays better than, is that the day that, I'm just trying to, I mean, we're here on a Monday, I'm just trying to establish days of the week right now. Is that,
Mondays, I don't really have a routine schedule,
okay, I
so.
get it, I don't either. What if we said like December 1st? And that accommodates for being out of state, and we said that briefs had to be filed or submitted.
That works for me.
7 days before that.
So, backing that up, that would be a brief due on the 24th.
I'll tell you.
Yeah, that's,
Right.
yeah.
But
Yeah.
how about the following Monday for the hearing? And the reason I'm saying this
Sure.
is that once he compiles the record, I won't be able to.
December 8th? December 8th?
Yeah, it could be-
I want to ask the appellants, what's your schedule like, or what your usual schedule? Are Mondays okay?
The eighth would be fine for you.
The 8th, okay, hang on.
And then-
I'm okay on the 8th. I just said this out loud earlier, but the written submission, if they wish to do it,
For December
I just
1st?
said 7 days in advance. I'm also mindful that's a Monday after Thanksgiving.
Right.
Maybe on Tuesday.
Yeah,
Okay,
sure.
I'm tough.
I mean,
so to avoid conflict with the town, select board meets the 1st and the 3rd
so that'd be.
Tuesday of the month. EDC meets on the second second Monday of the month.
So that's that day.
The 8th there's an EDC meeting,
Who was
Oh,
that?
that's
What's
wrong.
economic development.
Is that who met before us?
What time do they meet?
They meet at 6
And that's on a Monday,
Monday.
so we talked about maybe doing the Tuesday.
The second Tuesday of the month, the calendar, the town's free. It'd be the 9th.
Tonight?
so that-
And
that's just-
Wednesdays are good too. We don't have any meetings on Wednesdays.
I'll throw this out there. How do people feel about some of these meetings? I got an idea are gonna get long, like they already are. I don't know what you guys' anyone's schedules like for meeting during the day at all, or in the afternoon, starting in the afternoon. I don't know what people's work schedules like.
Well, for those of us who do it for a living, sure, but, you know,
Mhm.
the parties that live in these
What do
in
you?
here, you know.
I don't know how.
It's a normal workday.
As long as it ain't snowing.
Right? Yeah, sure.
Oh,
That's, no, I get it.
Yeah, I schedule feelers around.
Going back to the 8th, is that this location is the conflict?
No, the town
Right, I think
office.
they're looking at the 9th now.
So the 9th would
Tuesday,
be,
the 9th.
I'd be happy to meet early, or even if it was, well, you may have a work obligation. The 9th, 3 PM, I'm just throwing out times. The December 9th, I'm looking at balance, got
Is that,
December 9th is what you're suggesting for a meeting
that's,
at 3 o'clock?
or.
we're asking if I just threw out as an idea, can people meet earlier? Because if these last a while, I don't know. You've got school.
I'm also going for a living.
Yep,
So I
understood.
can't make 3 o'clock.
Is 6 o'clock,
What?
that work,
That's fine.
or 5, we'll go 5 o'clock or 6 o'clock?
Once it's finished, I don't think there'll be a lot of argument.
6.
6 o'clock.
There'll be questions for you.
And what
Yeah,
I
was it gonna be here or over there?
Well, the meeting can be here. I've got to schedule the gym, so I have to find out if this building is open on that day. But we have alternative locations that we could schedule the meeting should we not able to meet here. We can have access to the Snow Dusters Club. We have the fire station. We have a smaller room next door. It just depends on how many people be in attendance. Preferred to have a space that's large enough for, comfortability and such.
So let's maybe start with this, so
December
assuming we can find a location, December 9th, 6 P.M. work,
Some night, 6 p.m.
okay?
Briefs for the second.
Brief due the 2nd,
Does that need to be submitted to the town office by a certain time of the day?
so my suggestion would be email submission would be fine, and why don't you email it to, myself and Charlotte?
Yeah, are you expecting the parties to copy one another? I
Doesn't matter.
don't have an email address for you. And I'll get it to you right away if I have one, but if you're sure, that's fine. We can set up that.
You can send it to me, Nick.
Yes, I can.
Perfect.
So just submit it to me and Charlotte, and I honestly don't care if you do it until midnight. If you want to do it by 5 p.m.,
Yeah.
doesn't matter. So just submit it that day, email.
You'll still have an opportunity to speak at the hearing if you don't get it in. So it's like,
Remote
it's,
possibility that we're about.
No, I don't, it's up to the board.
what's the question?
So both parties would be submitting kind of at the same time, here's our position. we'll call it. The question is, well, can there be a written rebuttal before your meeting, which you could allow if you wanted to. It's,
Oh,
but I think at the meeting yourself, you'll have the opportunity
Yeah,
to
we'll just
speak to that.
keep
I
that.
mean, I think we have questions, we'll ask. If we're not sure what
Well, she's saying she has a rebuttal to Val's.
Right, what I'm worried about in a situation like this is, particularly what the other side's per se, not represented by council, is misstatement of law. And that's something I usually want to clear up in writing in the law, this is for these reasons, as opposed to having to deliver.
I would just, if you want, like you did today, if you want to prepare a written document and bring it with you,
And just
I think that'll be fine.
Yeah, and one thing, part of the process from my standpoint, I do think it will help from an efficiency standpoint in terms of presentation. I would still suggest, give the parties the opportunity to present it. The ordinance also allows any interested persons to comment. So that, I don't know how long that will take, but
How do you, what's
we'll
your,
get there. when we
yeah,
get
as I
there.
say, how do you feel about, I've been part of different meetings. People were given timeframes to speak, particularly on, I'm just thinking for.
That can happen. My test is always called the reasonable
Yeah,
test.
absolutely.
So you may have a room full of people.
They're all gonna say
Well,
the same thing. It's like,
you want to make sure everyone gets a chance to speak. There might be 2 people here.
yeah.
And you might be a little more liberal, okay? So that's a way of saying reserve the ability to have time limits to call it. But I would always suggest in this form, be flexible with that.
Sure.
But we'll gauge it when we show up
Okay.
on December 9th.
All right, sure. All right. What else do we need to accomplish tonight?
I think the only thing I would suggest on this is working with you. I'll draft just a little procedural order for you that reflects December 9th, continuation of the appeal December 9th at 6 p.m. PM, written submissions by electronic.
Sure.
I'll put in there who to send it to. You can sign it as long as the board's okay with that. I'm seeing nods head up and down. That's
And I think you have my email address, I think, or.
Yeah, no, that's okay.
Yeah, sure.
I think from my perspective, that takes care of item 4 on your agenda. Now, item 5, as you know, is a separate appeal filed by Interstate 5, you can say that. And they have a request to continue that to a date to be determined, I'll say. They do not, and I don't want to mischaracterize them, they don't seem to be pressing for that appeal to be heard early or immediately. So there is under the ordinance timeframe that you're supposed to do that, but again, they're not pressing that. So I do think you should allow them to address their own appeal in the schedule. But my impression is there's no need to set a specific date on that because they're not asking for that. But they want it to be continued to a date to be potentially later determined.
Were you looking for like maybe after this one was finished, then go forward with that one, or?
This is the situation with under subsidy. There is a hard deadline for filing an appeal 3 days after the pending hearing.
Right.
The snooze and lose.
Sure.
There were substantial legal issues raised during that proceeding, and we preserved them. We had noted them in an appeal as grounds for an appeal. However, that's the word. The business just wants to get going, and we need an opportunity to mitigate the impact of the delay that was caused. So, for example, the original operation start date was supposed to be the beginning of June next year. It's more likely to be September. No, it's actually the big process. So we've got, plus that dynamic changes the access to funds we have. So we're in the middle of a complete kind of recast of this whole project. Now, it's no secret. We've dug a hole. We're going to be pouring concrete. I mean, in good faith, we intend to proceed with this project. We just need to do what we need to do to get it back on track as best we can before we actually say, hey, is it going to be really hard? I mean, it really is. We had to file an appeal. We preserved our rights. We're not pushing for anything. We do know that there's been at least a 3 or 4 month delay in kicking off the project as a result of the appeal. We believe that a town was precluded from diving into the whole wastewater treatment system because of the state statute. But we have to look at it. It will cost us more to be right than it will just to conduct business.
So thank you. So if we were to, I mean, I'm all about, we've got enough on our plate kind of thing. Having said that, I think that, if they, we do owe it some due diligence and to at least not have it go on in perpetuity either.
Correct. No, I think.
We're sensitive to that.
Yeah.
We don't.
So how long?
My suggestion is say, I'm mindful there's 2 separate appeals on parallel tracks. Sometimes you can later to do one and the next.
The second appeal would be tonight, but we could do it. You're not, didn't want to push it on right now, but it could continue on. We don't
There's
have
some
to.
fairly substantive issues that require careful legal thought and consideration, not to mention figuring out what the full impact of the decision was on the actual.
Right, you said.
We don't know all of that yet. We haven't, gone down to the green sheet.
So
here's my suggestion.
We're not
Lauren-
going to hold something over you. We just.
I don't think we are.
We're going to meet December 9th.
Yeah,
I think December 9th, you revisit the
All right.
possibility of scheduling.
Sure.
Because once you schedule something, there's a 20-day
Yes.
notice.
Right.
There's a lot of lead time to meet anyway.
Sure. And hopefully by then, I mean, we're talking on the 9th, I mean, what are we, 6 weeks from now? now in the night,
Yeah,
and maybe you'll have some more answers and be in a better position to.
we'll have some, but one member in particular is being very, very slow.
Hmm.
You know, and we're also dealing with government agencies.
The government is closed right now.
And government is
Oh,
closed.
okay. Yeah, okay, yep.
It's a non-functioning government.
Yeah.
Right, so you see our dilemma.
I got you. Okay.
Um,
Well, that's certainly a circumstance that
Yeah.
makes us a little bit more
We
merit
basically
to it.
just want to dark on the field and figure
Sure.
out the business.
Well, we'll see where we're at on the night.
The only thing left
Yeah.
is to adjourn.
I make a motion to adjourn the meeting.
All right. All in favor? Anyone opposed? I don't. So, thank you.
No worries. Glad you made it.